I'd like to welcome you. Opportunity and the great opportunity to bring in a new member as well as to have the oath administered to our current member, Alex Chilafilio, and Joseph Mallory is our new candidate. So I'm going to turn it over to Judge Megan Shanahan, please. Could you please administer that oath?
Very good. Mr. Triantafilou.
Sure.
Raise your right hand and repeat after me. I, Alex Triantafilou,
I, Alex Triantafilou,
do solemnly swear
do solemnly swear
that I will support the constitutions of the United States
that I will support the constitutions of the United States
and the state of Ohio,
and the state of Ohio,
that I will enforce the election laws,
that I will enforce the election laws,
protect and preserve the records
protect and preserve the records
and property pertaining to elections,
and property pertaining to elections,
and perform my duties as a member of the Board of Elections
and perform my duties as a member of the Board of Elections
to the best of my ability.
to the best of my ability.
This I shall do as I shall answer unto God.
This I shall do as I should answer unto God.
Congratulations.
Thank you.
Raise your right hand. I, Joseph Mallory,
I, Joseph Mallory,
do solemnly swear
do solemnly swear
that I will support the constitutions of the United States
that I will support the Constitution of the United States
and the state of Ohio,
and the state of Ohio,
that I will enforce the election laws,
that I will enforce the election laws,
protect and preserve the records
protect and preserve the records
and property pertaining to elections,
and property pertaining to elections,
and perform my duties as a member of the Board of Elections
and perform my duties as a member of the Board of Elections
to the best of my ability.
to the best of my ability.
This I shall do as I shall answer unto God.
This I shall do as I shall answer.
Thank you, Judge Shanahan. Nice to see you.
Thank you very much. Now we will have the book signed by our clerk, Rick Hoffman. Is he here? Present or? Rick? Alex and Joe will now sign our clerk's book to make it even more official.
Hi, Rick. Right here? No $5, huh? Got off cheap today. Thank you.
Thank you. Now we're officially calling our Board of Election meeting to order, and I'd like everyone to stand as we do the Pledge of Allegiance. And Tip, can you lead us in that, please? Pledge allegiance to the flag
Of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. I'd also like the records to indicate that proper notice has been given for our meeting as required by the Ohio Revised Code 121.22. And next, and we will follow the agenda because it is a very busy agenda to the best of our ability. So we have next is the board reorganization pursuant to Ohio Revised Code 1211.22. And in that, I'm going to turn it over to Alex because to make a motion.
Yeah, I'm going to make a motion at this point in our reorganization process to appoint Gwen McFarlin as our temporary chair.
Second.
All in favor of that motion? Aye. Any opposed? The ayes have it. Madam Chair, the floor is yours again.
Thank you very much, Alex. Next, I'm gonna ask Chip. This is also part of our reorganization meeting where we reappoint our director and deputy director, and like Chip, if you could make a motion, vote for us to appoint our director, Sherry Poland.
Madam Chair, I move that we appoint.
I'll set, well, thank you.
Okay, that motion has been made.
Yeah, I think Joe seconded.
seconded.
Sorry. Mhm.
All those in favor?
Aye.
Anyone opposed? Anyone abstaining? That motion carries.
Congratulations, Sherry.
Congratulations. Next, I'd like to make a motion that we appoint Deputy Director Sally Crystal to her position, back to her position, and I'd like all those in favor?
I'll second the motion.
Okay. Motion has been made and second. All those in favor?
Aye.
Anyone opposed? Anyone abstaining? That motion carries. Congratulations. Thank you, Sally Crystal.
Madam Chair, I now have another motion here in our reorganization process, and that is to stay consistent with the statute and ask that you, Gwen McFarlin, be reappointed as this board's chairperson in our new term.
All those in favor?
Aye.
Aye. Anyone opposed? Anyone abstaining? That motion carries.
Congratulations, Sally and Gwen.
Thank you. Thank you. Next, we have our Judge Shanahan. She's going to go to the AV department to complete the oath of staff.
Oh, I'm sorry, Madam Chair. First, she'll swear in Sally and I and the other staff
Oh,
that are in
okay.
the room.
Okay. Judge? Thank you. Oh, that's important, too. Yes.
Everybody please raise your right hand and repeat after me. I, and state your name. Do
I.
solemnly swear or affirm
Swear and affirm
that I will support the Constitution of the United States and the Ohio Constitution. Perform all the duties of my position to the best of my ability. Enforce the election laws. And preserve all records. Documents. And other property pertaining to the conduct of elections. Placed in my custody.
Congratulations. Let's give them a hand. Thank you.
I appreciate this opportunity, everyone.
Thank you.
Thank you, Judge.
And so the judge is now going to go to complete the oath to all of our other remaining staff. Next, we're going to, again, moving along with our agenda. Our board minute meetings from February the 9th, 2021 have been sent out and also reviewed by the board members. I'm asking for approval of those board meeting minutes.
I'll move approval of the board meeting minutes.
Do we have a second?
Second.
Okay, any more discussion? All those in favor?
Aye.
Anyone opposed? Anyone abstaining? That motion carries. Thank you very much. Next, on the agenda, I'm going to turn it over to you, Sherry. We have a hearing, the protest of Aftab Purevolve, City Mayoria petitions. Can you go ahead and take care of that for me?
Sure, that's correct. In your packet, you'll find a copy of the protest that was filed by Kurt Hartman on behalf of Mark Miller. There's also copies, and these are all circulated to the board by email, of memorandum and complaints, again, sent by Kurt Hartman, as well as communication from Don McTighe. And I believe we do have representatives from both sides present.
Okay. So we're going to ask then first if Kurt Hartman presents the protest on behalf of Mark Miller. Please, sir, if you'll step to the podium.
Kurt Hartman on behalf of the complainant, Mark Miller. I would point out at the outset, I understand, and we understand where we're coming to avoid chaos. I would remind the board members what
Justice O'Connor basically said it is our duty, that's the court duty, but it's also this board's duty as a quasi-judicial body. It's the duty to follow the election laws of the state, regardless of whether they lead us to the result we desire. County boards, she continued, county boards who ignore the rule of law, she decried county boards who ignore the rule of law, they to subjective evaluations for political. I'm going to encourage this board to. This board has the obligation to enforce the law. That law is the Cincinnati City Charter. The issue before this board at this stage right now is a purely legal one. We set forth that the Cincinnati City Charter calls the petition process in this, the mayoral race. Imposes the obligation, clear and explicit, that not only must the petition with at least 500 valid signatures be submitted, that attached to that petition, our petition, must be an affidavit of circulator. Pureval did not attach any affidavit of any circulator to any of the part petitions.
That is a legal requirement in the city charter. That was not complied with. That invalidates, and we cited to, again, to the board in our memorandum on strict compliance, repeated Ohio Supreme Court cases that indicate the lack of that affidavit invalidates the petition. Now, they make the argument, the legal argument in their memorandum about, well, it satisfied the form of the petition. That's Section 3A of the Cincinnati City Charter. We're talking Section 2A. This board has the obligation, under the law, under principles of statutory construction, to apply both provisions. Not to ignore one. Because if this board rejects this petition, you are effectively changing the Cincinnati City Charter and exercising from that city charter that affidavit requirement. And one of the things that got decried from the last November election, not here locally but nationally, was executive branch officials and election officials changing election laws. That's what you would have to do to reject this petition. You'd have to exercise that affidavit requirement. You know, it's clear in terms of what was submitted that no affidavit was attached. Now, there is the substantial compliance requirement with respect to the form of the petition. But again, the Ohio Supreme Court, analyzing comparable provisions of state law, said yes, while the form of the petition is there, all other provisions of law have to be strictly complied with. And when the statute says an affidavit, or when the charter says an affidavit, it requires an affidavit. There is the Dittmer's case out of Columbus, where their city charter required affidavits for the circulators. And the Supreme Court said the petition was invalid because it did not comply with the city charter. So that's where we stand, at least initially, on our point. I think the law is there. You've got to apply both sections, but you've got to apply the law. You know, one of the things they argue, well, we complied with the form, and therefore we can avoid that. Well, I'm going to tell you who else complied with the form was Kelly Prater. Yet this board rejected signatures on her petition because they had the wrong address.
Not yet, by the way.
Well, but the recommendation, let me put the recommendation of staff. It's the wrong address. Where on that form of the petition does it say you have to have the address as registered at the Board of Elections? It doesn't. Why? But why are you going to reject? Why would you, in theory, or likely reject? Because there's other requirements of law that they have to be complied with.
Mr. Harmon, are you talking about another case? We're talking about Aftab.
I am,
Purevolve.
but there's an implication.
I would,
Because one of their arguments in their memorandum is, oh, we have this safe harbor that we, as long as we got this form from the board, which there's no evidence in the record that they did. They don't have any evidence in the record as to when they got the form, who developed the form, who approved the form. Forms are supposed to come out of the Secretary of State, and I can talk about that statute here briefly. So they're saying that. I'm saying if that's going to be the case, if that is the legal standard, if you're going to exercise the affidavit requirement from the city charter, if you're going to take power from the people of the city of Cincinnati who have the ultimate power to amend their city charter. But if this board's going to act to change that election law, because, hey, it was the forms, they complied with the form, it has ramifications beyond this case. You rejected signatures because of the wrong address. That form didn't say you had to have the right address at the Board of Elections. Point that out. Finally, in terms of that statute 3501.38L, you go to the legislative history, you look at the report from the LSC. It was adopted in the 125th General Assembly by amended substitute House Bill 86. And in the LSC statement there, or analysis of the bill, it talks in the comments section, it says the act pertains to the use of outdated forms that no longer meet the requirements of current law. For example, an older petition may contain different language about the penalty for election falsification. It would prohibit the Board of Elections from invalidating a petition on the basis of the outdated form. That was the purpose and intent of that law. And even if you go beyond that, Directive 2019-17 from the Ohio Secretary of State, which this board is obligated to follow, talks about that provision. And it says the board must ensure that it is providing petition forms to candidates or issue groups the most current version of the prescribed form. That is prescribed by the Secretary of State. And what does it cite to that? 3501.38L. So that statute deals with forms approved by the Secretary of State, and to ensure that that if a candidate receives an outdated form from the Board of Elections, it can still be valid. That is not a reason to invalidate. But this isn't it. We're not talking Section 3A of the Charter. We're talking Section 2A, which is an affidavit. It's in there. Whether it makes sense, whether it's logical, is not for this board to decide. That's for the people of Cincinnati to decide when they amended their charter how they did. And if they want to change, the change is not by this board to change the election law. The remedy is for the people of Cincinnati to amend their charter. So I'll leave it at that. And like I said, at this stage right now, I think it is a legal issue. Part of their argument, though I do believe gets into factual issues, and I can do that in rebuttal. No further questions from the board.
I have no questions.
Great. Thank you.
Okay, is there anyone else that's going to comment? Mark Miller? I don't see him. Okay, next we're going to go down to Even Nolan, who's going to be present to represent Aftab Pureval. If you will step to the podium, and then we need you to be sworn in.
I think Mr. Nolan's an attorney, are you not, Mr. Nolan? Yeah.
Oh, okay.
Yep.
Sorry.
Sorry.
Sir?
Morning, Chair.
Good morning. Good morning.
I want to be clear that Aftab Purevolve picked up the petitions from this Board of Elections on January 14th. And it's our understanding it's the same petitions that were picked up by every mayoral candidate and the same petitions submitted by every mayoral candidate, and include the same certification on Aftab's petitions along with every other mayoral candidate. So the complainant today is protesting only the petitions of one candidate, despite the fact that all candidates picked up the same petitions and filed the same petitions. The complainant refers to the chaos that could ensue upon invalidating these petitions. I suppose the chaos he's referring to is that all petitions would need to be invalidated. Complainant files the protest under Ohio Revised Code Section 3501-39A2, and A4 references that if a petition does not meet the requirements of law, then it also shall not be accepted. So if the complainant were to prevail under this protest, then all petitions would need to be invalid. But I refer you, as complainant did, to section 3501.38L, which makes clear that if a candidate picks up petitions within 90 days of the filing deadline, then any issues with the law regarding the petitions that were filed should be overlooked. And that would be true of Aftab and of all of the candidates that picked up petitions. Getting into the legal argument regarding the affidavit, the complainant recites a certain provision of the Ohio Revised Code and cites any number of different cases that refer to an affidavit requirement. He suggests that, he notes in the memorandum that local law, the city charter, prevails over state law. Yet he continues to cite the same Ohio Revised Code. That, by the way, does not require an affidavit for petitions, only requires a certification, which the petitions include. He points to that provision of the Revised Code to then explain how it's been construed in Ohio case law and asks to apply strict compliance with respect to one provision of the city charter, but does not ignore, but suggests that it should somehow take precedent over the other provision of the city charter. That other provision is the petition that is prescribed by the city, that was put together with the help of the city's attorneys and this Board of Elections for use by the candidates. In the memorandum, the complainant cites a number of times what he would suggest is the legal definition of an affidavit, but only does so with respect to Ohio law and makes no reference at all to how the word affidavit is treated in the city charter. Within the city charter, the word affidavit appears a number of times. In some cases, it says that it is a sworn affidavit that is required. In this instance, that is not the case. So as a matter of law, we disagree that the affidavit referred to in the city charter requires any oath. But we also believe that the Board of Elections can rely on 3501.38L. It provides that a candidate picking up those petitions within 90 days from this Board of Elections and submitting them to this Board of Elections within that 90 days should be read to comply with the law. Thank you.
Thank you. Thank you, Mr. Nolan. Mr. Hartman?
The order in rebuttal. Firstly, I will object for the record and move to strike any declaration in terms of facts that Mr. Nolan makes. Lacks the personal knowledge that is required. And then he starts testifying about what every candidate did, when every candidate did this and that. You know, he says Mr. Pureval picked up the petitions. How does he know that? Other than hearsay. That's hearsay, that's improper evidence at this hearing. Quasi-judicial proceeding. The Symes case that this board had years ago, Supreme Court said I have to object, so I am putting on the record that clear objection, and it should be stricken. Therefore, there's no evidence in the record, by actual affidavit or otherwise, that when the petition was picked up. He also starts testifying about it was put together by the city attorneys. It wasn't put together by the board. And I confirmed with Ms. Poland yesterday that, this board didn't do it. It's the city that distributes it. That is distributed by the city. But be that as it may, that section does not grant carte blanche to ignore any other election law. I gave that example of the addresses. You have wrong addresses. That form of petition doesn't say it has to be the address on file with the Board of Elections but those signatures will be rejected. And why? Because other provisions of law also apply. If the form said just put your name, because if you look at the form under Section 3A of the Charter, the form says name. Petitions that actually got circulated said signature, which is probably better and more accurate. But if you did it strictly with the form of Section 3A and put name, what if somebody printed their name? What if everybody printed their name? Those would be rejected unless that's how they sign their name down here. Why? Because a signature is required under law. That form doesn't excuse other provisions of law, other mandates of law. The intent and the purpose of that section is simply to ensure timely, if an outdated petition is used, that it's not going to be invalidated because the law changed on something. I have to comply otherwise with the law. I have to apply Section 2A of the city charter. So we have no evidence that, back on section subdivision of, no evidence that the board itself distributed, no evidence in terms of when the petitions were picked up, distributed, no evidence in terms of development of that petition. It's a city. And if you look at the duties of the board under Chapter 3501, it's not for this board. This duty of this board is not to develop petition forms. That's the duty of the Secretary of State. Those are the forms that are addressed. You got to read all these statutes in paramateria, related to one another. Finally, Mr. Nolan said two more things. He says, well, an affidavit under the city charter, this might be an affidavit. No, it's not. That's that Dittmer's case out of Columbus, which didn't, the Columbus charter, like this charter, didn't define an affidavit. Ohio law clearly recognizes what an affidavit is. It says, yeah, state law only requires the certification under penalty of election falsification. It doesn't require an affidavit. Historically, though, Ohio law used to require circulators execute an affidavit. Law was changed in 1974. We cited that in our memo. And what you really have is, and most city charters mirror state law. The United City Charter did. But when state law changed in 1974, the city charter did not change and has not changed. This section was most recently amended in 2001, and it was not changed. The affidavit requirement stays, is still there. And so while yes, the cases we cited reference state law, they're comparable provisions. 3501.38E talks about the verification. Under state law, at this stage, since 1974, is simply under penalty of election falsification. Prior to that, it was by affidavit. 3513.261 talks about the form of the petition. It must be in substantial compliance. But the law that this board is obligated to follow, as decreed by the Ohio Supreme Court, says those are two separate and distinct things. While the form must be in substantial compliance, requirements for the circulator, be it by certification under penalty of election falsification or by affidavit, is strict compliance. 3501.38E, the comparable provision to Article 2 or Section 2 of the Charter, requires strict compliance. It was not met. And as I opened up, Chief Justice O'Connor talked about, it's not a political expediency, not political whims, it's not personal desires, it's not political desires that dictate the decision. Dictates the decision is the law. And the law was not complied with. Right now, we just have a protest with respect to Mr. Pureval's petition. That's what's before the board. That's what we're arguing. Ramifications are what they are. Don't change the election law. It's not the role, it's not the function of this board to change election law, to change the Cincinnati City Charter. Thank you very much.
Thank you. Thank you, Mr. Hartman. Mr. Nolan, do you have any comments? Additional comments?
Sure, thank you. First, I would say that I suggested that Aftab picked up the petitions on January 14th. Certainly, this office would have knowledge of that since it was this office that gave him those petitions. It was also widely reported in the media that he picked up the petitions on that day. And I was here with him turning in the designation of treasurer form when he picked up those petitions. So at least clear to me that he picked them up on January 14th. Complainant will continue to rewrite a definition of affidavit as it applies under the city charter of Cincinnati, again by referencing how that term has been interpreted in other cities in Ohio, not in the city of Cincinnati. And I think I heard him also suggest that the petitions were put together by the city's attorneys for use by this Board of Elections. He refers to the revision of the Ohio Revised Code, moving away from the sworn affidavit to the certification, and that it happened in 1974, and suggests that because language didn't change in the city charter, somehow it should be read to date back to the language before 1974. But I think this board recognizes that the election for mayor in the strong mayor system did not come about until 2001. Section 3A of the charter was not adopted until, I believe, 1999. Certainly, it would not have been keeping the language that was in place from prior to 1974. Thank you.
Thank
General, I
you.
have a question for you. Mr. Hartman has said a couple times that that we would be rewriting the election law. Do you have a specific response to that argument?
He's asking you to interpret the word affidavit the way that he is suggesting with respect to one particular section and ignoring section 3A.
Would we be doing that? Would we be rewriting the law?
Absolutely not. You would be reading it just as it is written.
I have a question, Mr. Nolan. My understanding is the term affidavit does not always mean you have to be sworn in. If it's not indicated there, it's not applicable. Am I correct?
I think it would depend. The cases that the complainant has cited suggest in certain instances under Ohio law, in certain contexts, the word affidavit should include a sworn statement. But in the cases that he cites, it distinguishes between the use of affidavit under Ohio law in certain circumstances, acknowledges that under federal law, it doesn't necessarily mean that an affidavit is a sworn statement. And none of the cases that he cites refers to how the word affidavit is used within the city charter, again noting that the word affidavit in some instances is referenced as a sworn affidavit, and in others is not referenced as a sworn affidavit.
Thank you. Thank you.
Madam Chair, I think, is everyone finished with Mr. Nolan?
You have any questions?
I
No,
think
I'm finished.
Just to be fair, I think due process mandates a final word from the
From
moving
Mr. Hart.
party. So
Yes.
unless you have some objection, I think the moving party probably has the last. I don't know if you have anything else, Mr. Hartman.
I want to address Chairwoman McFarlin's
Question about an affidavit. It is absurd for any attorney to stand up and suggest an affidavit is something other than a sworn statement before an official officer authorized to give oaths. Can cite no case where an affidavit is other than a sworn statement before an officer authorized to give oaths. And why can he not do so? Because it is absurd to suggest otherwise.
Mr. Hart, for argument's sake, can, in your view, can the city rewrite or define for itself what an affidavit means?
I think not the city in terms of the city solicitor's office. The city,
I mean, in the charter,
the charter, they can define it, yes, but they haven't. And because what it does is it tracked these city charters, the Columbus Charter in the Ditmers case, the Cincinnati City Charter, they tracked state law pre-1974. A lot of these city charters parallel significantly state law. And so the question is, when the city voters first put in the word affidavit, what did they mean? When they readopted that provision, there was amendments to Section 2A in 2001, and they kept the word affidavit in there. I would be lost. I would be dumbfounded to see an affidavit as anything but a sworn statement before an officer authorized to give oath. It's defined that way in the revised code. It's defined that way repeatedly by the Supreme Court. Go to the civil rules. Talk about in the Rule 56 summary judgment, not to get into law too much, but it talks about affidavits. And if it's not sworn, it's not an affidavit. If it's not an oath administered before an officer authorized to give oath, it's not an affidavit. That is the law. And that's the purpose, is to enforce that law as written in Section 2. That is a mandate for an affidavit attached to the petitions, not part of the petitions, but attached to the petition. It wasn't done. So that's the only
Okay.
thing I really wanted to say. Where we get this new definition of affidavit. You know, hopefully not in the 21st century, because it's been that way for centuries.
Thank you.
Madam Chair. I'm
Yes.
Sorry, Mr. Hartman. Sorry, I have a couple questions for you. Your argument hinges on complying with Section 2 of the city charter, correct?
That is the basis for the protest.
Right.
Correct, that he did not comply with all the requirements of the city charter, specifically Section 2.
Specifically with respect to the affidavit.
That was not the part that was not attached to the part petitions. It uses attached.
I understand. Is there a definition of affidavit in the city charter?
No. And I would suggest it would be absurd to put a definition of, what is a city charter? It's basically the constitution of the city.
I understand.
You put a
Right.
definition of affidavit in the United States Constitution? No, that's not what constitutions do. They don't define stuff.
I understand. I appreciate your argument, but I'm just trying to understand that your argument essentially says that we have to strictly comply with the city charter as it pertains to this issue.
Strict compliance on the part of Mr. Pureval was required.
Yes.
Yes, because it does not provide for substantial
Basically regarding the issue of an affidavit.
attaching an affidavit
Right.
to the part petitions.
There's no definition in the charter, and I understand your argument. Again, you don't need to.
Rewrite the charter. If you start redefining affidavit, you're rewriting the election law too.
Okay, but it goes on, the charter goes on to say that the nominating petition paper shall be substantially as follows.
In Section 3A.
Right. And it goes on to describe what the language should be. And then we have the part petition that says affidavit of circulator of petition.
And if you look, if you look at Section 3A, it doesn't use that title, affidavit.
I understand.
It
It's
uses
a
the
statement
title.
of circulator.
The statement, that is substantial compliance. We did not have to have verbatim. And there's other variations between 3A and the actual petition that was used.
So, from your perspective, the fact that it is not a sworn statement is what makes it defective.
It was not sworn before an officer authorized to give oath. It did not comply with what was required as an affidavit. And honestly, neither this board nor the city solicitor's office can change the meaning of the Cincinnati City Charter. Just because you put a title affidavit. Whatever was an affidavit in today, in 2001, in 1974, in 1960, is an affidavit. I mean, other than Mr. Nolan, I'm hard-pressed to find an attorney that would suggest an affidavit does not require an oath before an officer authorized to give.
Okay, thank you.
Anything else? Thank you.
Thank you.
And I think in all fairness, since Mr. Hartman has brought up a couple new items, I think in all fairness, Mr. Nolan should also have an opportunity, and I'm going to, otherwise, what I'd like to do, based on the different discussions that we've seen and been heard, I'm recommending that we go into executive session to discuss threatened litigation.
So I'll turn to our counsel. I think actually Mr. Hartman used the magic words quasi judicial proceeding, it seems to me. Yeah.
Thank you.
And I just additionally, for the record, it seems to me like, given all the papers we've seen, looks an awful lot like imminent litigation as well. But nevertheless, I think under the quasi judicial proceeding exception to the Open Meetings Act, we can go into executive session. So I will make a motion now that we move into executive session to consult with our lawyer.
Any more discussion?
We need a roll call vote.
Roll call, please. Yes.
Aye.
Yes.
Thank you.
Make a motion, we come out of executive session.
Roll call, please.
Second.
Yes?
Aye.
Aye.
Okay. What is the judgment of the board?
Mr. Stevenson, again, you have advised this board for a long time. The suggestion's been made that we would be rewriting election law, and that's something we obviously take very seriously. Can you address that for the members of the public and this board?
The city charter requires substantial compliance. It does not require strict compliance. The fact that the term affidavit is used in one section and then a form is provided is sufficient for substantial compliance. And Mr. Purevolve's petitions, along with every other mayoral candidate's petition, substantially comply with the requirements of the city charter and Ohio law. That's my advice.
Thank you. Thank you, Mr. Stevenson. Any more comments from the board?
Madam Chair,
Yes.
I move that the protest of Aftab Purevolve Cincinnati mayoral petition be denied.
Any more discussion? All those in favor?
Aye.
Anyone opposed? Anyone abstaining? That motion carries. Thank you. Now we're going to continue with the agenda, please. Next on the agenda is certification of the Cincinnati mayoral petitions. And Ms. Sherry, I'm going to turn that over to you.
Yes, Madam Chair, we would just request that if there's people present who was for the last agenda item, if perhaps they could move to the overflow room so that those that are present for the next item could come into the room.
Thank you. I think that's a valid request.
In your packet, you have a document entitled Hamilton County Candidates List filed for the May 4th, 2021 nonpartisan primary election. There are 6 candidates on that list. Staff reviewed those candidate petitions and found those petitions to be sufficient. They had the required number of valid signatures.
Ms. Poland, quick question. Did you request that those individuals who are not related to this case please leave the room so that we can make room for those individuals regarding the next case?
Well, I think that Mr. Nolan and Mr. Hartman, would you mind, since the protest is over, just going to the overflow room?
I have an interest in the upcoming.
Okay.
But is Mr. Hartman representing the next coming one? No. Then I would like to suggest that you leave the room, please, as requested by Ms. Poland.
I would note that there are about 15 people in this room.
I didn't single just you out. I asked for you and Mr. Nolan, because we have the overflow room we'd like you to go to, please. We'll wait.
I think that would accommodate then, because we just have one person that would be on the next list. Does the board want to address the first 6
I'd
candidate
like
petitions?
to wait until your request is recognized. Yes. Oh, he is.
I think what we're suggesting here, Madam Chair, with, in the interest of moving this along, the next item is to approve the 6 candidates. It would seem
We
that
could do Aftab first.
But Mr. Purevol's on that list. So if we certify these 6 people to the mayoral ballot, that perhaps will make Mr. Nolan.
Okay, that's fine.
So why don't I make a motion that we certify those 6, if you're okay with moving it along?
Yes, let's do
They
it.
usurp your authority here, but anyway, so I'll move that we certify those 6 candidates to this November ballot, actually to the May ballot.
For the May ballot. I was gonna
May
say.
ballot.
Yes. Need a
Second.
motion? All those in favor?
I want a discussion.
ahead.
Do we need
Discussion.
to state for the record the names of the candidates that we're certifying?
Historically, we just refer to the document that's in the board's file, but whatever's the pleasure of the board.
Well, why don't we just, historically, we've always done the other way, but based on the question you've raised, I'd like records to indicate that we have Gavo Bertrup, we have David Mann, we have Herman Najoli, Raphael Prophet, Aftab Pureval, and Cecil Thomas.
Thank you.
So, all those in favor? Aye.
Aye.
Anyone opposed? That motion carries. Thank you.
The next document,
I'm sorry, following order, the order, what your request was. Mr. Nolan has left. I'd like to ask that Mr. Hartman now leave. We're just asking you to go into the overflow room. Well, then let's bring Mr. Nolan back in. I mean, if we're gonna do this, I'm not gonna ask one person to leave and the other one hasn't. So let's bring, could you ask Mr. Nolan to return to the room, please?
So the record's clear. I don't know what we were going to throw Mr. Hartman out of the meeting.
No one was
yeah.
gonna throw him out.
Yeah, I think the suggestion was that he go to the overflow room, but I will tell you, Madam Chair, in the interest of moving this along.
I'm just asking.
Fair
We
enough.
requested one other individual to leave as well, and he did in overflow room. If he is still here, I would like him to return.
Fair enough.
Thank you. Okay, Sherry?
the next document in your packet is entitled Hamilton County Candidates List, Insufficient Petitions Filed for May 4th, 2021, Nonpartisan Primary Election. This list contains 3 candidates, and after board's review, we found their petitions to be insufficient. They did not meet the requirement of 500 valid signatures.
Okay.
I believe there are people here who have interest in this. Just, again, we're in a public meeting here. And one thing I want to just make clear at the outset before we make a motion and rule and decide on this question is there's a difference procedurally from where we were a moment ago. Mr. Hartman properly filed a petition, a protest under the Ohio Revised Code, and we heard a protest. These folks have not formally filed protests.
That's correct. So we're just asking, they want to have, they did not have sufficient signatures, and they want to have a few minutes to outline their objectives. And then we can vote on it. So a few minutes, please. Okay? So, is there Adam Kohler here? And would you please take the oath as well when you step to the podium? Can you issue the oath, please?
I do.
Thank you. Mr. Adam, thank you. Adam Kohler.
The board, good morning.
Good morning.
sir.
My name's Adam Kaler.
Good morning, sir.
I filed a petition of candidacy for mayor, and the result of that was insufficient signatures, and I'm here today to challenge it. But I would like to commend your staff, because this was no easy task, finding these valid signatures. So everyone here has been great, and I just wanted to make a note of that. Brian?
So he's going to be speaking for you?
We've outlined our case, and Brian is gonna.
Is Brian an attorney?
No.
Okay.
He's with the campaign.
Okay. Need to,
Oh, sure.
an oath, please.
Thank you, and I'll go fast because I know. Julian, it's Brian, B-R-I-A-N, last name's Julian, H-O-U-I-L-L-I-O-N. In reviewing the petitions, when they were returned to us from the Board of Elections from their initial count, we found a few discrepancies. I believe you have Mr. Kaler's initial count is 456, is that correct? In your packet?
I do want to clarify something regarding that. The initial count was 439. Board staff questioned a few part petitions that were circulated by an individual that does not live in the city of Cincinnati. We asked for an opinion from the city solicitor because their charter does have that residency requirement. We received an opinion late yesterday from the city solicitor's office, but it doesn't really answer the question. You have a copy of that in your packet. We did, as a courtesy, check those signatures, that if we received an opinion from the solicitor that those part petitions could be counted. That's where it would be the 456 valid
Okay.
signatures. But that would still be a question to come before the board on whether or not those few part petitions could be counted when they were circulated by someone that lives outside the city.
We were not aware of that information, so just utilizing the 456, and then I guess the rest will have to be decided by the board. We cannot speak to that requirement, but on 4 of the petitions, we found that the number of valid signatures written at the top was incorrect. There should have been 5 more based on those 4 petitions with incorrect numbers listed at the top, which would bring it to 461. And then there were 3 part petitions that were not counted, as the date on the back on the affidavit fell before some of the dates on the front. That nullified, my understanding, was 36 legitimate electors that had signed the petition, and just with the date, which is actually really not required by state law to be there, just the affirmation, the signature by the circulator, and the correct number that they have witnessed is all that's required. In the charter, the form of the petition states substantially that it should appear as such, and that's the only place that a date is actually listed or shown, but that is not anywhere. It's not in section 2 of the charter. It's only in the petition. So not having that date correct, I think, would still substantially provide that that person affirmed that they saw those number affixed. So that would be another 36, which brings us to 497 signatures. Then on top of that, we found another 7 signatures that could be confirmed. There were 3 that they had their house number incorrect but had the street number correct. Had 2 that did not list a street number, but we were able to confirm their address and that they were registered on that street at the address we found. There was a name change, which the elector had not made that change yet, but we were able to identify it from her address. And then there was 1 voter that did not put the date on the petition, but was a qualified elector at that address. The date is really utilized to ensure that it had been signed within the year prior required. And as it was in the middle of the petition, we think it could be easily identified as not having violated that requirement, and as such can be considered a legitimate signature. So just with those 7 more, that puts Mr. Kaler's petition over the required 500. There are more that had the incorrect address, which I'm sure will be addressed soon. Some of those have updated their address since then, once they found out that they were not registered, but they were priorly registered voters. How many were there? These 6.
Okay.
So we are well into 500 that would provide the veracity of signatures to allow Mr. Kaler to be on the ballot. And we request that he has substantially met the requirements, and that you certify him for the mayor.
Can you, so you said over 500, can you repeat what that actual number was again?
Sure. If we're using the 456, we have 5 that were 5 petitions that were not did not have the correct number of valid signatures at the top. For instance, petition number 5 shows 11 valid when there are actually 13. Number 6 shows 13 valid but had 14. 30 had 23 valid but actually had 24. And page 46 shows 5 but it had 6 valid. So that's 5 there. Then the 36 signatures that were not counted because of the dating issue on the affidavit, which nullified all of their
Right, I got
signatures.
those.
Okay, and then we have at least 7 more that we were able to identify from the information on their, on the petition that showed that those 7 were verified registered voters.
Which brings to, what was your final total?
With that final total, we are at 456, 461, 496, I'm sorry, 497. We are at least 505.
Okay, that's what I was looking for.
Sorry.
Thank you.
And I believe that's.
We got some voters registered for you though, so.
Thank you.
Thank you.
Madam Chair, could we have staff speak to the, he mentioned something about incorrect numbers at the top of the petition, and then the date on the back where the circulator affidavit is before the date on the front. Can you explain that?
Yes, as far as the valid and invalid number, I believe that on those few part petitions, it looks like our staff person who checked that petition just put the number on the wrong line. So for number valid, they put 11, and invalid, they put 13. And it should have been switched. But the calculation of the total number of signatures is done through the voter registration system, not a hand count of what's on the label. So I think even if you hand counted these, it would still get you to the 456. This just now came before us, so it isn't something that we've had time to look into, but just a quick glance, I believe that would be the case. And then as far as, you should have copies of the 3-part petitions that were referred to, that were circulated after the date, but do you have the part petition number of those?
We also have affidavits from each of the people that circulated those petitions saying that they witnessed those.
So the petitions would be number page 38, page 47, and then the last one was never stamped or given a number. It was just,
It's the very last one in your packet.
Okay. Okay.
So for example, the very last part petition in your packet has 4 signatures. The signers, so the voters who signed the petition, dated the signing as of February 1st of 2021. The circulator statement states that those signatures were witnessed by the circulator as having, as of January 28th, 2020. So that's why the signatures on that part petition were not reviewed by staff. And then I believe it's similar for the other 2 part petitions that are in your packet, page 38 and 47. On page 38, the first 2 signatures were reviewed and accepted by the board because the voters signed on January 13th. The circulator statement is also signed as having witnessed those signatures on January 13th. But all the remaining signatures were dated after the 13th, and so those signatures were not reviewed by staff. And then it's similar for page 47.
Madam Chair,
Yes.
if I could ask counsel,
Jerry, I'm not seeing, can I want to clear something up. Page 47? Is that the one that's,
The one by the,
oh, this one. What's it? Oh, okay, all right. Okay, I got it, all right.
after that. Right. Right.
I'm sorry, Madam Chair, thank you. Mr. Stevenson, we've heard from these two gentlemen, they're asking us to take action here. What is before us technically right now?
Nothing.
And
Nothing. I mean, protests are supposed to be filed with specific objections, and that did not happen here.
So basically, this is a hearing, they're just expressing it's a hearing, it's not a protest.
well, I understand that, but they're here asking us, I think you're going to ask us to take action here with respect to the testimony you just provided. And my question is, are they here appropriately under, the rules that control us?
Well, understand this, the board's not required to review this situation. If you do choose to review it, you would have to accept the evidence that might be presented. There are some things, I mean, typically with a protest has to be in writing, and it has to lodge specific objections to the board's decision on the petitions. And right now, we have nothing in writing from Mr. Kohler at all.
The deadline to file such a protest is when?
Friday.
So that's what their next step would need to be. Because
Correct.
this is a hearing again, for us to listen to any concerns briefly that they have. So if they want to pursue it further, then they need to file a protest, and you have until Friday to do that.
And Madam Chair, I would suggest that it's not a hearing, it's actually more in the nature of a public comment. Now,
Yes.
I
Okay.
know that they were sworn, which probably was not correct procedure, but the bottom line is they're offering public comment, and they're saying they have some evidence, but, the protest needs to be filed in writing.
Yeah,
Okay.
so and frankly, that's why at the outset I suggested that there is a procedural difference between where we were with Mr. Hartman and Mr. Nolan engaging this protest discussion and what we're doing here. In terms of next steps, frankly, there is new information that's been provided even to the staff today, correct? And
Correct.
and I'm subject to being corrected about this as well, but we can decide to reject. They can still protest. Mr. Stevenson, do you agree?
That's correct.
Okay, they can still protest if we decide to reject. The next question I have is, can we table it long enough, if the board desires to do so, to give the board a chance to review this further information? Are we on any deadline at the moment as it relates to denying certification? Because we're going to, and the only reason I mention that is because we do have to come back next week anyway, right?
Exactly.
Yes.
I think you can table it if you choose to do so. I mean, it's
From a board operations perspective, what does that look like?
Since we cannot finalize our ballot until you certify the charter amendment that's still pending before the city of Cincinnati. So I think as long as, we had a decision by, the end of next week, we would still be able to stay on schedule with producing ballots timely, et cetera.
That is, if they plan to file a protest.
I believe the deadline to formally file a protest is this coming Friday.
This coming Friday.
Yes, and as far as the board hearing the protest, I think as long as the board ruled by the end of next week, we would still be able to meet our obligations in printing our UCAVA ballots, military ballots.
Okay,
timely.
because that's what's important.
Yeah, that was my
Yeah.
main concern. So getting sort of back to on the agenda, from where I sit at least, we have this question before us right now about, it's a report dated 3/2/2021, and it's captioned Hamilton County Candidate List Insufficient Petitions. We were prepared to vote on that. At this juncture, that would also, by the way, include Ms. Prater and Mr. Young. I believe maybe Ms. Prater is present and maybe wishes to have some similar kind of public comment.
Exactly.
But in the interest of keeping us procedurally in the right place, I'm going to suggest we table, and I'm certainly, Ms. Prater's here, so I'm not looking to, eliminate her right to talk. I'm happy to hear from her, but I'm suggesting procedurally, perhaps we just table this question of the 3 mayoral candidates who have insufficient petitions to give the board more time, and also recognizing that there may be a protest filed, which means we may have to do this all over again, or some version of it.
Madam Chair?
Yes.
Mr. Stevenson, Mr. Triantafilou just laid out, a timeline here and possibilities, but to protect the interests of Mr. Kaler, Ms. Prater, and potentially Mr. Young, should they file a protest, or, you're not their lawyer, so I'm maybe asking you an unfair question, but if we table it, I just want to make sure they understand procedurally what's likely to happen. If we table it, and we come back next week without a protest, there might be a situation where they haven't been afforded the opportunity to provide all of the evidence that they want and protect their rights.
But,
So I guess, and maybe it's not even a question, I'm sorry, it's just that, we want you to be aware of what your options are. And so that you have the opportunity to avail yourselves of, everything that's available to you with respect to this challenge. So you will probably want to look into that and just make sure that a protest, consider a protest or not, but that's available to you. It looks like we may table this until next week to give our staff further time. But again, I would just urge you to make sure that you do everything you can to protect your own interests on this.
Well, that was going to be one of the questions I had, and I don't know if you can answer it, is we wouldn't be protesting because you haven't made a decision. So would it be requesting a hearing, much that you had for earlier today, in order to present our case?
I think whether or not they've made a decision is immaterial. If you want them to consider something else, you need to file something in writing.
and remember, again, the time frame that you have. All right, thank you.
Okay, thank you very
Thank
much.
you.
Thank you both very much.
Next, we have Kelly Prater. Can you step to the podium, please?
First, I'd like to say thank you all so much for allowing me to speak. This is kind of off topic, but one of the last times I spoke before the board, and if you all don't mind, I do have like some respiratory problems, so I had to pull my mask down. One of the last times I spoke before the board when it was on Broadway is that any governing body should accurately reflect the community that it serves, and so it gives me great pleasure as an African-American woman to see that we not only have an African-American woman who was on the board, but also an African-American man. So congratulations on your appointment to the board. The reason I'm here today, though, is to contest the filings that I submitted. On January 15th, I submitted 939 signatures. I'll be honest and say that I did not check every signature, and so when the board called and said that I did not have enough signatures, I said, okay, well, let's go out and get more signatures. So out of 939 signatures, I was informed that only 441 were valid. Like I said, I checked the signatures. I went to areas where I normally go collect signatures. I've never had this experience before, but again, I trusted the board. The second time, I checked every signature. I turned in probably 1,068 signatures, but of course, on every filing, you're only allowed to give 1,000 signatures. So I received a call back, and they said that there were 723. They processed 703. I misunderstood them. I thought they said 703, but there were 723 of the 1,000 signatures that they counted. Out of the 723, they said I had 389 valid. So at that point, I questioned why the other 277 signatures were not processed. And the response I received from, I believe, Sally and Cherry was that I would have to bring this issue before the board. As I was looking through my signatures on the back of the circulator of the petitions, it says exactly how many signatures you want processed. At one point, Ms. Poland did reference the Ohio Revised Code regarding markings on the petitions, which clearly states that in Section G, I think it's 3501 Section G, it says that a candidate can mark out signatures that they do not wish to have reviewed. Again, on the affidavit of the circulator of each petition, I noted how many signatures I wanted crossed out. When I reviewed the signatures, there were signatures of family members and friends that were crossed out. And I said, there's no way in the world I would have crossed out. But, you know, that was neither here nor there. So for the sake of time, again, this second set of submissions was submitted on the 2nd of February. So the first set was submitted 939 on January 15th. The second set, 1,000 signatures on February 2nd. The third set of signatures, just given the fact that, you know, we were nearing the deadline, and I'm like, I don't want to argue. I don't want to run the risk of not having enough signatures. I went out and collected another 970 signatures. As the staff can attest to, I was here every day checking the signatures. And based on my review of the second set and the first set I had the second set I had 580 valid signatures. The second set I had 572 valid signatures, again, based on me checking the signatures. So remember I said the second set, they decided not to process 277 signatures. On the third set, I counted 572 valid signatures. They decided not to count 148 good signatures. Now, the time frame for which I was forced to go out and collect signatures, knock doors, put my health at risk, was during a snowstorm. A snowstorm. 17 degrees weather. I felt like I was getting frostbite, but that's neither here nor there. They decided not to count 148 signatures. I did have an opportunity to sit and speak with Joe Mallory about this, and out of that 148 signatures, 93 valid signatures would have taken me over the threshold so that I could have been certified to the ballot. So what I'm saying here today, or what I am presenting is I'm contesting, and I do intend to submit a protest to the signatures, that I had not only enough valid signatures on the second set of petitions, but also the third set of petitions. And so, I mean, that is my testimony. Again, I did ask Sherry to make copies of each of my petitions. I did 3 times the work of any candidate who ran. I collected 3,000 signatures. 3,000 signatures this period, because I have a heart for the people, and I know that city government is going through so much, and they need someone who's going to speak against the corruption. And so, again, you know, my prayer is that the board members will take a look at these signatures, and validate me to understand I have enough good valid signatures, and validate me or confirm me to the ballot or certify me to the ballot.
Thank you.
Thank you.
Thank you, Ms. Kern.
You're welcome.
Okay, did you
Madam
say-
Chair.
Yes.
This, I guess like the previous gentleman, you heard the comments that you can file a protest
Yes.
by a certain date, like March 5th. So
That's our next
I believe
step.
that's the same applies to all these rejected.
Absolutely.
Okay.
Absolutely.
Yes, thank you so much. I do plan on filing that today.
Thank you.
You're welcome.
Did you mention another person? I don't see another name down.
I know Mr. Young is also on the list. I didn't know if he had someone here in the interest of fairness.
Ms. Poland, is there anyone that's not on the list?
We have not heard from Mr. Young, or been given any indication by him that he would be, have comments to make before the board, or would be questioning the results of staff's signature checking.
Can I?
Go.
Yep.
I got
So, as I've suggested already, that perhaps we table this question. I do think Mr. Julian made a good point, Dave, and I think you answered him, but I just want to make sure it's clear. Is it procedurally better for us to vote consistent with board staff recommendation at this juncture? It's not going to change our posture on the protest necessarily. Or again, I'm the one who suggested tabling it, but now I'm just asking if procedurally, do we make it more ripe for them if we reject them, which is what the board staff is suggesting we do?
I don't think that that's necessarily a prerequisite for them to ask to reconsider the staff's decision. If you want to table it until you have the evidence and make the decision based on that, after they've presented it, that's fine.
Yeah, my personal view, it remains the same. I just wanted to get you on the record about that. My personal view is to have it tabled, only because we do learn things in public comment that can influence the public body, and we did get some new information from Mr. Kaler, and frankly, Ms. Prater also brought some new information to us in the public comment section that would make me want to table this. So I think procedurally what I'll do is I'll move that we table the insufficient petition candidate list for our next meeting, which is going to be scheduled at the conclusion of this meeting, but that's my motion, that we table this question.
Just question on your motion, real quick. Procedurally, we have a process procedurally, so we can go over and beyond that process to move with the motion that Mr. Triantafilou has made. Is
Sure.
that what you're saying? Okay.
I second that motion.
All those in favor? Aye.
Aye.
Aye. Anyone opposed? Anyone abstaining? That motion carries. Thank you. Next on our agenda, trying to catch up, certification of charter amendments. Sherry.
Yes, we've had 2 charter amendments from the city of Cincinnati filed with the Board of Elections. They're on the list contained in your packet, and staff recommends certification of these charter amendments.
I'll move that we certify those 2 charter amendments to the May 4th, 2021 primary ballot.
Do we have a second?
Second.
All those in favor? Aye. Anyone opposed? Anyone abstaining? That motion carries. Next, write-in candidates. Sherry, do you have a report?
Yes, the board had received 1 declaration of write-in candidate for the Cincinnati mayoral race, but yesterday that candidate withdrew. So there's no action needs to be taken by the board regarding write-in candidates.
Thank you.
Great. And we just move on to the next section on the agenda, and that's certification of Judicial Municipal District 2 candidates. Sherry, can you present that, please?
Yes, 3 candidates filed petitions for this particular race. They are listed on the document in your packet. I will note that this contest will not appear on the May election ballot. This contest appears on the November ballot, but since the filing deadline has passed, staff has reviewed the petitions. We recommend certification.
I'll move certification of the 3 individuals, Helmick, Johnson, and Ty, to the November ballot for the unexpired term in Judicial District 2.
Second.
All those in favor?
Aye.
Anyone opposed? Anyone abstaining? That motion carries. Thank you. Next is, Sherry, review of the November 2020 Presidential General Election Anomaly Report. This is a continuation of a discussion that we had in our previous board meeting.
That's correct. This is the board's continual review of any voting anomalies from the presidential election. Just to refresh the board's memory, the board had directed staff to issue a second letter to voters that we had not that had not responded to staff's either phone calls, emails, or a first letter that was sent to the voter, and trying to speak to them and to determine why they cast 2 ballots in this election, in the November election. Just to remind the board, again, only 1 ballot was counted in these instances. The deputy director and I did hear back from several of those voters, and we believe they had reasonable explanations, and that there wasn't any type of attempt to have 2 ballots cast or anything fraudulent. However, there's 18 voters we still have not responded to, or that have not responded to the board, and they're indicated in gray shading on the anomaly report. I do want to bring, there's an additional 3 voters that their second letters were returned by the post office as undeliverable. So those voters, we would assume, are no longer at the address in which they're registered to vote, from which they cast a ballot in November. And then wanted to bring the board's attention to voter number 119. This was the voter who communicated to staff that the voter's been living in New York City since 2014, and did vote as the board directed, we sent that voter a letter along with information on the residency requirements to vote in the state of Ohio and a cancellation form. And we have not received that cancellation form, nor have we heard from that voter. And that letter was, I believe, mailed by February 12th.
February the 12th. And so this is March the 2nd. Okay. Second letter, okay, those that did respond were fine.
Yes.
Though the individuals that did not respond, the next step from the board, what is your guys' pleasure? I'd say exclude them from voting.
Well, I think there's, if I'm hearing this properly, there's sort of three questions. One is, what do we do with the 18? Do we treat the 3 any differently? And then the New York 1.
That's correct.
Correct.
Yeah. I'm going to start with what, for me, is an easy one, and that is the New York 1. We have, information that this person has been out of the jurisdiction for 6 years, continues to vote here and shouldn't. We've made every reasonable effort as a board to contact the voter and give them an opportunity to fix it by changing the registration. And, given that they've not responded to our most recent inquiry, again, it's not our decision, nor is it really ever our decision as to who gets prosecuted, but it is our decision as to who the prosecutor's office, who we decide to send over for additional review. So on that one voter, I'm going to make a motion that we refer that case to the prosecutor's office for further review.
Second.
Okay, any more discussion? All those in favor? Aye.
Aye.
Anyone opposed? Anyone abstaining? That motion carries. So what about the thoughts, your pleasure on the 18?
On this last voter, the one we just talked about, the question in my mind then is whether or not we'd move to cancel her registration. That's something we're certainly authorized to do, is it not, Dave? We can cancel a registration of a voter that
Fine
we.
if they don't, yes.
Yeah. What we've typically done here is challenge the person's, no, I'm going to take a step further. Based on the information before us, a failure to cooperate from this voter, clearly, to me at least, living out of state for a period of years, I'm going to move that we cancel that voter registration. And that's on voter 119. I'll move that we cancel her registration.
And if I recall, that had been a point of our discussion the last time and was decided that we would give her one more chance, but I support that. I need a second on that motion.
Second.
All those in favor? Aye.
Aye.
Anyone opposed? That motion carries. All right.
I think on the other three, I'm working backwards now. The 3 that we delivered one letter, it did not come back as undeliverable, just to be clear. The second letter went out and now came back as undeliverable. These are people who attempted to vote twice, and again, we all know that especially with COVID, there were situations where people voted absentee and then voted provisionally because they weren't clear, and we've, I think, been more than understanding on that topic, especially when there's a reasonable explanation. But those 3 people now having moved and having provided us no additional information, I'm prepared to refer all 3 of those for further investigation as well. So I'll move that they be referred.
Okay. Any more discussion?
Second.
You have a second? Okay, all those in favor? Aye.
Aye.
Anyone opposed? Anyone abstaining? That motion carries. So have we, wait a minute, have we
So on the question
discussed
of
all of them? Or
sorry.
we still have the 18?
Yeah, we do, but on the question of the 3, I think at this point I'm going to move that we also cancel their registration, given that we've sent a second letter that's undeliverable. What would typically happen here, Sherry? Again, we typically won't do that step until we've reached the end of the letter.
Correct. There's, I think, 2 different things, and I will refer to our registration
Sure.
administrator as well. I think one, based on having that mail received as returned as undeliverable, we could send a confirmation notice to the voter, which is forwardable.
Yeah.
So we could do that and then report back to the board on the results of that confirmation notice. Or you could challenge the voter from voting from that particular address, or maybe that's a step you could take.
That's typically what we've done, is it not?
Right.
Not to interrupt, but.
I don't, typically we would follow, and correct me if I'm wrong, Mr. Eckert, first we would send the confirmation notice that's forwardable. And then go from there on whether or not to issue a challenge.
So
I'd-
what, so
I'd
the
support that.
turnaround time on the challenge, on the confirmation letter, what, would give them, maybe to our next board meeting in April? March,
I
April?
would advise the board meeting in April,
That
correct?
makes sense.
Yes.
Okay.
So I'd be for that. I'd be in favor of sending a confirmation notice, and I don't know that we need a motion on that, or do we?
No.
Because that's
no, I believe
process,
so.
that's what we
Yes.
usually do. Okay.
Madam Chair?
Yes.
Since we're going to send the confirmation letter, we just voted to refer them for further investigation, correct?
Was it,
Was that those three, or was that a different three, Alex?
It was those three.
So we should probably
yes.
hold
do a
off on that
confirmation with those
until we
all
go
three.
through the confirmation letter process.
Fair enough.
Yes. So.
Fair enough.
so
All
we
right, then
need
I'll
to-
move the rescind the previous action of the board that sent the three people for further investigation.
Yeah, I
Need a
withdraw my
second.
second.
Okay. All those in favor?
Aye.
Aye.
Anyone opposed?
Just
Anyone
so,
abstain?
yeah,
Just
just
to
so
keep it
everybody's
clear.
clear. Yeah, we're continuing to pursue this matter. Rather, we're doing it through a confirmation process, challenge, potentially referring them. But we continue to diligently try to resolve this.
Right?
And again, that next board meeting officially is the one in April,
Correct.
because we may have one in between that time, so I just want for
Yes.
clarification. Okay. So, have we tackled all of these? Or what about the
The
18?
18 is still
Yes.
pending. Anyone else have thoughts?
Well, the other thing that we had sent have we sent confirmation letters to those 18?
Those 18, we've sent 2 letters so far now, asking those voters to contact staff to discuss the matter. Both of those letters were not returned to the board as undeliverable, so we're assuming the voters received those letters, but did not respond.
So so the letters were officially confirmation letters?
They were not confirmation letters. They were the, basically letters asking the voters to contact us about this anomaly during the November election. If you recall, that was an initial letter, then the second letter was a little more strongly worded for the voter to respond. And they've not responded, and we have not, the letters have not been returned as undeliverable from the post office. So we're assuming those voters live in those addresses and received those letters.
I think in all fairness, we should send a set of confirmation letters out. I mean,
How's the
that way we-
confirmation letter any different than what we've just
A
done?
confirmation letter is forwardable.
But these didn't bounce back, right? The 18
Right, so
didn't.
these didn't bounce back, so we don't have any indication. Versus the 3, we have reason to believe they're no longer at those addresses, and therefore are unaware that the board is trying to reach them.
So they didn't get our second strongly worded letter, so to speak, right?
Correct. And that's different than these 18, because their letters were not returned to the board, so we assume they did receive them.
So can we use
I'd
those?
take the extra step.
I would, as far as the confirmation letters,
Yes.
I
Fine.
agree,
Fine.
in all fairness. So, motion to send this confirmation letter.
Do we need a motion?
I don't think we need a motion for this, do we?
Do we?
They have the staff do it.
So the anomaly question will be back on the board's agenda in the future, right?
In April.
Fair enough.
The
correct.
board meeting in April. Okay.
Thank you.
Thanks for that clarification as well. Next, approval, discussion on the precinct election official reduction. Sherry.
Yes, staff is recommending that for our single precinct polling locations, we staff those with 4 precinct election officials. But in our multiple polling places for the May primary/special election only, we're recommending a slight reduction and double precinct polling locations from 8 to 6. and triples from 12 to 10, and from quads from 16 to 14. We believe that would be adequate staff for this type of an election. But the board is required to vote on that in public session.
Okay. Those numbers seem reasonable, taking into consideration, we're still in a pandemic, it's primary as well, and we still have coverage in those locations as well. So need a motion?
I
Do we
move that
need
we
a
approve the
motion?
allocation.
Second.
All those in favor? Aye.
Aye.
Anyone opposed? Anyone abstaining? That motion carries. Thank you. Next is board policy updates.
Yes, we have two policy updates for the board's consideration. The first is our social media policy. This is simply just some minor tweaks made to the policy to include the recently created position of digital communications manager within the social media policy.
Okay.
And the changes are outlined in blue.
I'm aware of this, I'm familiar with this, I don't have anything else, any comments. I mean, it's something that we've discussed before. We need a motion.
I'll move approval of the recommended changes to the board's social media policy.
Second.
Any more discussion? All those in favor? Aye. Anyone opposed? Anyone abstaining? That motion carries. And method of board meeting notice.
Yes, this policy we recently drafted, which basically just outlines the practice of the board for years. Just when we were reviewing, we noticed that the board hadn't really adopted a formal policy on how your meetings are noticed. So this would put into policy what's been the practice of the board for many, many years.
Housekeeping, right?
Yes, and this was reviewed by our legal counsel.
Are there any major changes? Just
No, it's just putting into policy what our practice
what
has
we've
been
been
for
doing
years.
from a best practice perspective.
Correct.
Okay.
Correct.
I'll move approval of the board meetings policy as amended.
Need a
Second.
motion?
Second.
All those, any more discussion? All those in favor? Aye.
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 Anyone opposed? Anyone abstaining? That motion carries. And thank you. Other business. It appears that we will have another meeting scheduled before our board meeting, official board meeting in April. So we need to do a calendar check, taking into consideration the timelines that we are working under to make sure that we meet the criteria for all of, the timelines that set there, as far as elections are concerned. So I overheard some discussion earlier. If there is a hearing, which it sounds like there is going to be, what do your calendars look like? Could we look at Friday?
Friday the 12th is wide open for me, but Mr. Gerhardt's out of town or something?
I'll be flying back, and be back shortly before 1.
On Friday?
Yes.
Would that give you enough time to get from the airport to here?
I hope so, yeah. I mean, it should. For 1 p.m., I should be. So anytime after 2, I think. But, I don't know.
Why don't we look at 2:30, as long as we get out before, some people may be going to restaurants later. So 2:30?
2:30 works for me, and Mr. Gerhardt's going to owe us all for having to work on a Friday afternoon.
That he is. Mr. Mallory.
I would love to accommodate Mr. Gerhardt. Yes, that's fine with me.
I was going to see if we can,
Welcome aboard, Mr. Mallory.
yeah, I was going to save that for other business too, by the way. But
So that's 2:30,
March
March
12th.
the 12th?
12,
March
yes.
12th.
Okay. That'll work. Any other business?
I just want to echo what Chip said, and we didn't say it enough at the outset of the meeting, as we had lots of serious business, but do want to welcome Joe to the board. Great to have you. I think this board has done great work over the last many years, and I know I'm honored to be part of it, and I look forward to working with you, Joe, so welcome.
Thank you.
I am
Thank you.
excited as well, and I just want to say he just was baptized by fire. And, because it was a very interesting, challenging meeting, and what better way to come in than to be baptized by fire? It was just not a quasi meeting, it was a really good, great meeting. And I want to thank all the staff. I want to thank all the staff for the paperwork that you put down, all the time that you took to make sure that we could get through this meeting and get through it in a somewhat timely manner. So again, thank you, staff, for the great work that you continue to do. Need a motion to adjourn.
So moved.
Second.
All those in favor?
Aye.
Anyone abstaining? That motion carries.